Good morning, everyone. We'll call the meeting to order. Um, We have a quorum and everybody's seated. Need a motion on the minutes.
Second.
Any additions, deletions, or corrections to the minutes? Seeing none, all those in favor?
Aye.
Any opposed? And a motion on the consent agenda. Does anyone wish anything removed?
Move to approve. Second.
We have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed?
Mr. Chairman,
Yes.
who is Representative Gruen sitting for today?
Whoever. Pick one.
Representative Schmidt.
Sure.
Do you have an extra agenda? I don't seem to have gotten that.
Yeah. Who put these flags up? Who's up first, Mike?
I believe it's Department of Revenue 2022-132 is the first on the regular agenda. This particular proposal, there was a conditional approval filed. However, there were 5 substantive comments and 1 comment to jail car still remaining on that conditional approval. The first was on page 4. It's an unclear comment about all amounts charged must be included in the amount of the gross charge, which conflicts with later provisions in the rule, as those later provisions lay out exceptions. So therefore, it's not all charges must be gross charges. There are actually exceptions. So there are some issues with that particular rule. And I don't know if the department wants to respond to that before I move on to the next comment.
Good morning. Keen Ming Wong, Department of Revenue. So just want to start off at saying that these rules were, as Attorney Ricard has pointed out in her comments, that these were already addressed in the 2012 JOCA meeting, and it was passed back then. And I looked through the files, the historical files, and couldn't really see any notes that was written down as to what was discussed back in 2012 in the JLCAR meeting. I couldn't bring any more additional information to sort of discuss the outcome of that. But ultimately, it was approved, and then I went back to the RSA in terms of these the 1602.01A. And it is addressing RSA 82-A:2 Roman 5, all the charges that's considered as gross charge, and then specifically, I think it is also addressing subpart E, where it says charges for services. So which is so that list of charges there is the exception of what should not be in gross charge. And then subpart E says that charges for services which are not provided in connection with the origination or receiving communication services. And so this part here, it looks like to me when I was reading through this, 1602.01A addresses more on this subpart E, where it says, okay, what's not here would be here as accepted as should be considered as taxable items in the gross charge.
s- if
So
the-
this is not resolved?
no, not at this time.
Thank you. Would it be reasonable to say that all amounts except those specifically exempted? I mean, really, you've got, the exemptions are very specific and
Right.
narrow.
Yeah.
You just need to include, make sure that you're acknowledging them.
Yes, it looks like it's like a sort of a an opening statement to say, okay, all charges here are gross charges, and then there's this listing here as the attorney, the staff attorney had mentioned, it, making reference to the later rev rules of 1602.02, 1602.03b, and those, well, those are what services by the retailer that shall not be included in the gross charge. And in 16, so just for an example, 1602.02, it says, subpart A, says services provided by a retailer that shall not be included in the gross charge. But then when you look back to 1602.01, it does say all charges, but used by customers in connection with origination or reception of communication services shall be included in the amount of gross charge, whereas in 1602.02, so what are the services that is not in there? So in A1 it says those which are not directly or related. So there's no conflict. I don't see the conflict between 1602.01A and 02A1 because it sort of carves it out.
So just to make sure I'm clear, you're saying that the later sections are different than the origination or reception of communicating services, and that's why they're not considered exceptions to all gross charges?
It's not. I would say there might be some overlap in terms of trying to carve out what's not a gross charge. And I think the 1602.01 is this blanket statement trying to capture all that is not in the exceptions.
So I would say that language is therefore unclear because you're saying that there's some overlay, but those are exceptions when you're saying all charges need to be gross charges.
I guess my other point may not be a strong point to say that, but since these rules have been in place since 2012, we have not had any issues from.
Yeah, we're not bound by the errors of the past.
Yeah. But also, I'm just trying to point out that we haven't received any kind of confusion comments from taxpayers or retailers who are filing these returns, saying that okay, yeah, we're not. There's no certainty or there's confusion in their part.
If there are no more questions regarding that particular comment, the next comment, which first appears on page 14, but then is reiterated on pages 16, 22, and 23, is an authority legislative intent no to jail car comment. This has to do with that pains of penalty language we discussed at the last meeting, appearing on forms when there's no statutory authority for that. However, because it was discussed at the last meeting, and it seems the department is moving forward with legislation to fix that. If that legislation goes through, that would fix the comments on this particular rule as well. So the next substantive comment is on the bottom of page 14. It's an unclear comment that says that the statute shall apply, but it does not say what the statute shall apply to. In the original proposal, they had originally cited another statute, but in the conditional approval have struck that statute due to staff comment.
So the original language is that saying that the underpayment penalties shall apply to the communication services tax, RSA 82-A. And so receiving the comment from staff attorney saying that okay, shall not make reference to 82-A, that's the reason why I took it out.
Well, the problem was the way the rule was written in the proposal was saying that this statute shall apply to this other statute, but the statutory language did not reference that at all. So you were essentially using a rule to say that a statute shall apply to another statute, which is not within the authority of the department.
I guess so then we are okay to strike out that entire subpart B because it does say, well, I guess within the 21J32, it does say that that underpayment penalty does apply to RS 82A within that particular statute itself. So probably we don't need that in the rule here. That's fine.
If that's all right with the committee, to
Go
just
ahead.
strike that language.
Go ahead.
The next comment's an unclear comment on page 19. The department uses the term substantial to measure the penalty attributable to, or a measure to, of whether or not a penalty will be invoked to an understatement of tax liability. It's also used to measure the legal authority required to avoid liability for an understatement, which might otherwise impose that legal liability. So using the term substantial as a means of measurement to invoke a penalty and to say that whether or not someone has enough legal authority is not clear and is in violation of RSA 541A1 because there's no criteria on how the department is actually going to determine that on a case-by-case basis.
So for the first substantial authority comment, which is on 1611.01A2, and then it goes on to, if you look at 1611.01C, it says in determining whether a retailer or customer has substantial authority, so the department shall consider the following, and those are the things that the department will be looking into to determine whether there is that substantial authority by the retailer or customer. And
You want to make that motion based on Senator Gray?
I think that what we've heard here is that there's still a lot of staff work to be done on this one, and that the comments from the jail car staff really haven't been addressed by the department. And so I offer a motion for preliminary objection.
We have a motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Do you know where the office is? You should go visit them and sit with them and they'll,
okay. Thank you.
and
The next item on the regular agenda is item 2022-62 from the Department of Safety. This particular rule, the department also filed a conditional approval, which addressed a majority of staff comments. However, there is still one substantive comment remaining. On page 2, there's an unclear comment as the rule states that every sexual offender or offender against children shall register and references the statutes, but the statutes are circular in that the definition of a sexual offender or offender against children say anyone who needs to be registered. And then when you look at the other statute, the statute says that every sexual offender or offender against children shall register. So there's no real clear definition of what that is. This comment was made on the conditional approval text from 2012, and the committee did approve the language at that time, but it seems that there was no change to the statute since then.
who's here from safety?
I was told that a representative from safety would be here. It's not the normal attorney. She said that she was going to be out, but that someone else would be here, but it appears as though they weren't able to make it.
Do you have a recommendation on this?
I don't have a specific recommendation. As I said, this language was approved before, but once, as you said, Chairman, that we're not bound by the past. So if the committee feels as though this is enough to be a preliminary objection, we would allow the department and me more time to talk and then see if we can come to a resolution about that, or we can accept the conditional approval as is and leave that language there for now.
Representative McGuire.
Yes, thank you, Mr. Chair. I move we approve the rule with the recommendation that the department gets statutory clarification.
Motion and a second. Any discussion? All those in favor?
Aye.
Any objections? Next. Electrologists.
Okay, so this proposal makes changes to the licensing rules for alcohol and other drug use professionals, LADACs and LADACs, et cetera. The agency has filed a conditional approval request, but there are still a few comments that remain. The first issue is on page 17 of the conditional approval request, page 18 of the PDF. There's been some testimony submitted stating that the rule violates the statute because it does not allow for remote supervision on a platform like Zoom. The rule does allow for indirect supervision, and it defines that as being telephonic. The statute doesn't explicitly state that either clinical supervision or supervised practical training can be done remotely, and it doesn't define what indirect supervision means. It also doesn't define what a location is, whether a location can be a remote location. We know that technology like Zoom would allow for video and not just audio, like the telephonic, what's currently in the rule. But this may be a policy decision for the board. So that's what that first note is about. If you want, Tina could respond to that before I move on to the next item.
Good morning. I'm Tina Kelly. I'm the program specialist with the Office of Professional Licensure and Certification. And if you look under C of that section, it says supervised practical training that includes direct and indirect supervision. Both direct and indirect supervision are defined in ALC 301.01 I and K. And one of those, it just has to be a combination of both. One of those allows for telephonic and those types of, and we don't put specifically Zoom, we just telephonic or remote. And I can read the definition if you want me to.
I don't know about you, the others, but I don't actually need you to read that.
Okay.
What I would like to see is that if there's a reference to those things, that it be put into this paragraph as a part of the conditional approval for this, and therefore I think that would take care of the staff's objection.
It's allowed under, it's defined there. So do you want me to put in a direct, includes direct supervision as defined in 301?
Happy to have you work that out with staff.
Or indirect supervision
And-
as defined, yeah.
I can, yeah, that's easy enough to add. That's
Okay.
pretty much editorial, you'd say?
Um,
Or is that substantive?
It's a little, we can make it as part of the conditional approval request. Okay. So I'll move on to the next item, and that's on pages 26 and 27. It also involves a comment on page 33. Let me just scroll down there. Here, the rule is talking about the application or licensing requirements for those holding an out-of-state license. A testimony has been submitted stating that the statute allows for automatic licensing, but it doesn't. The board has to waive the supervised work and practical training experience to anyone submitting proof of active practice for a period of 5 years. Initially, we were thinking that the requirement of submission of an official transcript, as you see there highlighted, that's the subparagraph 4, that may be beyond what is necessary, given that the board has to waive those requirements, the supervised and practical training requirements. But the statute does allow the board to license folks whose academic study has been less than what's required in New Hampshire if certain other requirements are met. So we think that's probably the reason why this requirement is here, because without that, they wouldn't know what coursework the person actually has. But there is an issue around the rule language, and that's on page 27 and also on page 23, where it's talking about that the person has to have an active proof of active practice for 10 years. The statute talks about 5 years. So we've placed, like I said, that comment occurs also on page 33. And with that, I can let Tina address that.
Yeah, the clarification of why the board's asking for the transcripts is exactly correct. It's because it's so different. But we can change the 10 years to 5 years. I did look at the statute, and the statute's very clear. It's 5 years.
And then the last comment is on page 58 of the proposal, but 59 of the PDF. And that's really a comment letting the committee know that the board still does retain some fee authority in the statutes. And that's the only comments I have. And this is a conditional approval request.
Carol.
Yes, thank you. I move we approve the conditional approval request with the addition of the correction of 10 years to 5 years in at least 2 places, and the other editorial comments recommended by staff. And I believe that the fee authority question is being addressed in legislation.
Motion and a second. Any discussion? All those in favor?
Aye.
Any objections? Pharmacy Board.
Yes. So the board did submit a draft conditional approval. However, it sounds as though there was some technical difficulties over at the OPLC, which prevented them from officially submitting that conditional approval. But I was able to talk to Ms. Kelly prior to this meeting to discuss the remaining comments after reviewing that draft conditional approval, and came up with solutions to address those specific concerns. So at this time, the conditional approval would be what was submitted as a draft, in addition to changing the form that says pharmacist and advanced pharmacy technicians application that was submitted with the final proposal to pharmacists, certified pharmacy technicians, and pharmacy interns application to administer vaccines, to change the section where it says pharmacy license to just say license or certification, so that the certified pharmacy techs and interns could also use that application. And then to change the rule itself to say, instead of just pharmacists, shall apply pharmacists, certified pharmacy techs, and pharmacy interns, as the new statute does allow all 3 of these pharmacy personnel to administer vaccines at this time.
Questions? Motion?
So I think for this, you have, the department has to request the conditional approval based on the draft submitted and the other comments of Attorney Ricard, and then JLCAR has to waive the deadline because they're filing it here at
The motion to waive the deadline?
Second.
Any discussion? All those in favor?
Aye.
Any opposed? And
and then you would move to accept the draft conditional approval with the extra comments.
okay.
So move. Second.
Any discussion? All those in favor?
Aye.
Any opposed? Board of Veterinary Medicine.
Okay, this proposal let's see, is on the requirements for renewal, reinstatement, and continuing education requirements for licensees for veterinarians. There are two comments and on the amended conditional approval that you have before you. And I'll just mention the easiest one first, and that's on page 10 of the proposal and the PDF. There, the rule cites to the VET 800s, which doesn't currently exist, but the agency is currently in regular rulemaking for that rule set. The second comment is right there on page 1. The rules have been expired since January 28 of 2020. The statute does establish a health program fee, and that became effective in this year. And then the PLC has established some rules also in some other, has established some fees and some other rules, and those also have effective dates in this year. So the committee may have some questions about the collection of fees and any refunds that have been done during that time period in which the rule was expired and the statutes weren't effective.
We do.
Good morning. For the record, Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. With respect to the first comment regarding the VET 800s, what we would propose is to have the board adopt each set of rules concurrently at the same time so as to avoid reference to a rule that's not in effect. With respect to the fee issue, as the committee is aware, the Board of Veterinary Medicine was previously attached to the Department of Agriculture. They were in the process of rulemaking at the time that they were transferred over to the office. I think it was 2 budget cycles ago. The rules expired in January 2020, but obviously that was an oversight on our part in terms of not understanding that the fees were captured in our MLO database. That has since been corrected, and about 240 individuals have been issued refunds to date. It is a manual process, so it is taking some time. There are currently 1,000 licensed veterinarians, so it requires us to review each licensee record to assess whether or not a fee was improperly charged and to issue the appropriate refund. I did attempt to obtain some documentation to support that. Our reporting was a little bit difficult in that it's a manual process and includes protected financial information. But if the committee would like further documentation, we can continue to work on that.
Okay.
Okay, I had no further comment, and this is a conditional approval, actually an amended conditional approval request.
Carol.
I move we accept the amended conditional approval request and thank the OPLC for issuing the refunds without being nagged.
Thank you.
Second. We have a second. We have a motion and a second.
The only question that I have was about 800. The director had said
Yes, sir.
adopting them concurrently.
Yeah, I don't see it as necessarily as a problem that the rule set, that this rule refers to non-existing rules. They are in the process of doing regular rulemaking. I have reviewed the 800s, so I think that they're going to be moving forward soon with that rule set. I believe in the next month, right?
So we would be looking at a January gel card date.
Possibly a December, I think. It depends, but yeah,
Yeah,
the latest
depending
would be
Are
January.
we going to have a gel card by December?
One can only hope.
We expect so.
Wow. Turn off my mic.
Okay.
There has only been one instance in the history of Gelcar where they were not able to meet in December after,
Organization.
yes.
Okay. Did we vote?
I think you moved but didn't vote, right?
We're ready
Okay.
for the vote.
Okay.
Thank you.
So we have a motion and a second. Any other discussion? Seeing none, all those in favor?
Aye.
Any objections? And next.
Okay, next we have an amended conditional approval on the prescription drug affordability rules. This proposal would establish organizational rules for the board and rules outlining the board's operations. There are 3 comments to bring to your attention. We have received this morning from Representative Lang a document about 15 minutes before the committee began that I've not had a chance to review. And I have just forwarded, we've just forwarded that over to the agency as well. I can go ahead and get into the comments that I have in the rule. The first one is on page 18 of the PDF. And here, let me get down there to that page. Okay. Oh, yes. So actually, it's on page 1, and that's just an informational note there, kind of giving you the background for the rule itself, and the fact that HB 1208 had an effective date of 2020. So you may have some questions about whether or not the board has been meeting and issuing reports as required by the underlying statute. Don't know if you want me to go ahead and turn it over to Allison or continue on to the next comment.
Is your evaluation complete, or are you waiting for, do you still have other things to review?
Yeah, there are a few other things on here to go over. Let's see, like I said, this on the next comment is on page 18, and here also that page is going to say page 1 because this begins the second set of rules, the 300s. So here we've received a comment because the rule basically restates what's in the statute, and it does mostly do that. But the board has added some additional information around data sets that they're going to be considering in determining the annual spending targets. The board may need to do some additional rulemaking in the future as they kind of flesh that out in order to figure out what the spending targets should be. The next comment is on page 20 of the PDF, and that's going to say page 3 at the top. Here, the statute says that the board may look into, getting funds and grants and contracts to augment their assessment fees, and that is what the statute says. And in response to my comment, the board has struck that out, but we do note that often agencies do not have to commit their process for accepting grants, funds, or contracts within the rules. So with that, I had no other comments.
Mr. Chair, I don't know if in your question, you were referring to the email that Representative Lang had received. We have not reviewed that comment yet. Apparently and Representative Lang certainly can talk more about it, but apparently someone questioned the constitutionality of the fees in the rules.
Yeah, sorry about that, if that's what you meant. No, I have not reviewed it yet. It appears to be a 14-page document. And like I said, neither me nor the agency has reviewed it yet. As far as I know, this board is not assessing fines or fees per se. They do have some assessment fees, so I'm not really sure what exactly the issue is in the document until I've had a chance to look at it.
So, and this is outside of the public hearing process.
Yes, sir.
Hard to consider when there was an opportunity to comment.
So there are, this is a 14-page document written in 2013, so there's a large time gap, but it was written by Marcus Hearn, who's very well-respected scholar in the area. So it would definitely be something that we would like to review and consider. However, you have a few options. You can either approve today, do a preliminary rejection based on staff comments, which would give us more time to review this, and then we would have to potentially ask the board for a revised objection response. But if you approve it, we can also then still go back, take the time, review everything, and you can come back with a petition if something needs to be changed.
And I could report out to the committee next time, my review. And Christina's correct. I was a student of Marcus Hearn and have a great deal of respect for him. So I think receiving it at this late date doesn't give me an adequate time to really review his analysis.
Carol?
Thank you, Mr. Chair. I'm concerned that somebody brings forth an 8-year-old objection to fees and fines, which we have been imposing for however many years, which in this memo was written before this board was created. So I'm not sure how it can apply. It should be either applying to all entities in the state or it's obsolete, and I'm not sure we should take it more seriously than
So
seriously enough.
just based on my very preliminary review of skimming this 14-page document, I do think that he may have a point. He's connecting fees or fines or whatever you call them to the benefit or the thing that the person gets back. So you pay a fee, you get your license. And so I think in this situation there may be a point, but like I said, we can, if you do approve, we can go back and we'll do the analysis still and then recommend if a petition is needed. That way they can move forward and we will still go ahead and take the time to review.
Fine. In that case, what I would move that we approve the rule and request the agency to report on the cost benefit of their fees, because they should know what it is.
Second.
And that would be for an amended conditional approval.
Yes.
Any discussion? You're okay with that, Gary?
So I guess my only question is there a timeliness issue with this that forces us to move forward today, given the fact that we may have a constitutional issue?
So we
Is it-
just asked for them to go ahead and review. So
But we've approved the rule as it's written, and then they'd have to come back with another amendment and go through rulemaking again, or not?
No, to come back with an analysis that justifies that the fees align with the benefits that are provided to the people who are paying the fee. And if the analysis does not show that, then we can object and require them to return the fees or whatever.
Yeah. Sure. Representative Gary Merchant, to your question, Senator Reagan, yes, I'm okay with that.
okay. Any other discussion? Seeing none, all those in favor?
Aye.
Any objections?
Mr. Chair,
Yes.
I think that in light of this reminder that we keep an eye out for fees and expect future fee setting authority to have an analysis of the benefits, because we need that to decide if it's reasonable and constitutional.
Thank you, Representative McGuire. And Department of Health and Human Services.
Yes, sir. These two proposals, I'm going to lump them together because they deal with the same sort of issue, or they have the same issue. Both of these proposals make amendments to the rules on licensing and the radiation safety requirements for irradiators and for wireline service operators. There is one comment that's applicable to both proposals, both add a citation to HEP 4038, which is the rule on physical protection of Category 1 and Category 2 materials. The fiscal impact statement didn't address whether or not there would be an increase in cost for the entities to comply with HEP 4038. The agency didn't talk about it in its request for fiscal impact that it submitted to the LBA. And I reached out to the agency, and its subject matter expert said that and I'm summarizing here, and the agency is here and probably can correct me, that after 9/11, it was required to administratively add all the federal requirements to the licensing requirements. And I think those federal requirements were in 10 CFR 37. So it was added as an additional licensing, a separate additional licensing requirement. It sounded like now adding in this citation and requirements to the HEP 4038 will basically have no impact. But again, the agency is here and can answer any questions about that.
Good morning, Nicole Valenzola, Department of Health and Human Services, Administrative Rules Coordinator. Yes, thank you. Oh, sorry. Way to go.
Good morning, senators and representatives. My name is Augustinus Ong, last name is ONG. I'm the administrator for the Radiological Health Section.
So yes, as Attorney Reeves said, there are no new requirements being put forth on licensees. They've already been established in CFR and through the Nuclear Regulatory Commission. Therefore, this was an update to cite to include the rule. Yes.
Thank you for that information. However, the fact that it's new to the rule is, I can't believe that a new section of federal rules has no cost impact whatsoever. And I think that this change to the rule should have been addressed. And I'm very concerned that you think there's no cost impact and nobody needs to worry about a new federal regulation.
So it's not a new federal
It's
regulation.
new to the rule. It wasn't in the previous version. The fact that it was applied by the federal government is one thing, but if you waited 11 years to impose it, it's a new rule for people that are just looking at your rules.
Gives you citation.
Yes, I think I could address that. So since 9/11, the Nuclear Regulatory Commission issued an emergency order to secure the use of certain types of materials that are classified as Category 1 and Category 2. Those radioactive materials are of such high activity that could impact the health and safety of those using the material or for the security of this country. So that being said, then the emergency order that was issued by NRC shortly after 9/11 were to have the agreement states, of which New Hampshire is one, whereby we could, through that emergency order, to administratively add those security conditions onto the then current licenses. So that being said, that have existed since 9/11. So finally, NRC, I would say less than 10 years ago, finally issued the formal Part 38. Part 37, which is the security of the Category 1 and 2. So that being so, since those rules became, or regulations became fully adopted at the national level, that would enable the agreement states to then issue those rules, all right, under our own 4038, which is the equivalent part. So by having the 4038 now becoming fully adopted and effective, we remove the administrative conditions from those previous licenses, thereby creating a more, how would I say, correct version of the license, whereby it's the citation of 4038 instead of relying on non-existing 4038 and simply those conditions that were administratively added.
Sir,
Sir.
I agree that the federal agency issued this emergency rule. However, are you aware that our state constitution, not the federal constitution, forbids us from adopting any federal rule without legislative approval?
Yes, I understand that.
Well, it sounds like in 2011, you adopted the federal rule without legislative approval, and now you're trying to bring it forward saying, well, we did it 11 years ago, it's no big deal.
Sure. Okay,
And I'm very concerned that that is the case.
understood. Yes, 4038 is already in place, yes.
So I mean, I could be misunderstanding. The rule 4038 has already been in place. So 4038 isn't a new rule. It's just citing to it. It's just this rule is
Are there
pointing-
requirements on the licensees in section 4038?
I mean, I'm sure he can, Augie can speak to specific requirements.
Yes, well,
It's
in that
regarding
case,
category
these are new requirements for the licensees when they apply for it. It's a new section they have to comply with.
So it's not a new section they're complying with because they're already they're already doing it. They're already complying with it through this rule is just encompassing that citation, but that rule is already on those folks. They're already complying with it.
And when was that rule adopted?
I would go with that.
Yes,
Is that the
you've-
most recent section?
the 4038, which is the physical protection of the category 1 and 2, that was adopted effectively in May of 2016.
On whose authority?
Here, Joker.
Joker.
Just a clarification, is that the document that you're reading from, is that the rule? Is that the statute? Is it? And a comment on staff on after you get done answering the first question.
Okay, so HEP 4038 is on it's on the physical protection of category and category 1 and category 2 quantities of radioactive material. And it looks like it was adopted, as they said, in May of 2016. Whether or not whether or not the current entities are the exact same entities, I don't know. I'd have to dig into this a little bit, but to find out whether or not it sounded as if, from what the subject matter expert is saying, that swapping, it sounds really like they're swapping out the previous federal requirements, which were administratively added to the license for these requirements, which were in place since 2016. Whether or not they impact the exact same entities, it kind of sounds like they do. But again, I need to look at this a little bit more. Yeah, I think they do. I think that this, was a result of my comment and taking a look at the fiscal impact. Like I said, the fiscal impact request didn't address this thoroughly, and so it wasn't discussed at all in the fiscal impact statement that came out of the LBA. The agency couldn't get an amended fiscal impact statement because that's, there's specific requirements in the statute for that. So at the time when we discussed whether or not it would be worthwhile getting a revised one, where folks landed was to come and have the conversation in front of the committee, since they could not get an amended request. It does seem to be a technical oversight in their fiscal impact request that was sent to the LBA. The committee has in the past, approved such a thing. They've also not. So it's up to the committee, how you want to, what you want to do here.
Mike?
Thank you. Historically, this has happened before, where there may have been a fee that was in place federally for some time, and everybody had been paying it, but the agency decided to cite to the federal rule but not mention it in the fiscal impact statement. And technically, Representative McGuire is correct. It didn't exist in state law, in state rules beforehand. I'm not sure, I didn't review this. I'm not sure if the fee was actually in place in the rules, and they, instead of specifying that, they are just now referring to the CFR. I don't think there's a problem if that's the case, but certainly if they are just for the first time citing to the fee, then technically the rule has a change in it, imposes a fee that it did not impose before. And so that's been raised. I think Kim is right that in the past, committee has usually gone along with it with a notation to the agency, but that has not been a 100% scenario.
There
And-
isn't a fee.
That's what I was going
There
to.
are no fee requirements. This is
Exactly.
just adopting and discussing the additional category 1, category 2 content. So there isn't a fiscal impact because, again, per the agency and the expert did not identify a fiscal impact because there's no fees affiliated with this. It's encompassing and citing to a rule that's already been in existence of what is already been in the requirement. So that's why when Attorney Reeve brought it to me, I did ask her for her recommendation to ensure that we complied. Her statement regarding amended fiscal impact is accurate. And she said it probably actually isn't even, I forget how Kim phrased it, but it's not even like a thing probably. She was like, oh, it wouldn't even be worth it to go back. So we came here to answer if there were questions, but yeah, I just wanted to clarify that. Thank you though, Mike, but
Representative
there's no.
McGuire.
Yes, thank you. Whether there's a fee or not does not definitively say whether there's a fiscal impact. If this requires more secure or more expensive or more or traceable or whatever containment vehicles, that's a cost and it's a fiscal impact. And I'm extremely concerned that HHS in particular merrily adopts federal requirements without getting the proper approval. And I'm not going to vote to support this rule.
Oh, yeah, I mean, I wouldn't say, I wouldn't say it that way. I think, I'm new to this role. I'm doing how I've been taught and how I've been trained and with communication with the attorneys consistently and constantly regarding rules. Again, Nuclear Regulatory Commission and specifically the radioactives has had other they have other, I don't know if the word's agreements or there are certain things that we can't do because of the standards of NRC. So we fall back on because we have nothing else that we want to do, but there are things we literally cannot change content wise when it comes to this because New Hampshire is an agreement state with NRC. So it's not a falling back on the CFR. There are certain things we're not even allowed to change. So they're already, I forget what it's called. I'm looking at you guys, but
Yes.
sorry.
Okay, how these happen seems to be a separate issue from what costs are involved. It's not a matter of we yield to the feds because they give us money. It's how much does this cost the citizens of New Hampshire?
So again, we don't believe there is a cost associated with this. If I'll take whatever recommendation Attorney Reeve or Attorney Morrill say with respect to writing that there might be an indeterminable, but again, these licensees are already under these requirements. This is just a citation to it, but they already are mandated these requirements.
We're talking about the costs incurred in obeying these rules.
Was there a fiscal impact statement approved in 2016 when we approved this derivative rule?
I'm
Obviously,
sure there
nobody
was.
remembers.
I'm sure there was.
Well, that's something that needs to be, now that you're applying it to, in this rule, you say it's covered under the cost for that rule, which was previously approved.
Mike?
Thank you, Mr. Chair. If I can ask the agency, you've mentioned New Hampshire being an agreement state. Is there any codification in statute of New Hampshire being an agreement state?
Understand your question?
How did the New Hampshire become an agreement state? Was there a statute that specified that New Hampshire would be a member?
Oh, I see. It was back in 1966, whereby then the governor and the New Hampshire administration came to agreement with NRC that NRC regulations would then be, how should I say, transferred over to New Hampshire to manage. So with or without New Hampshire, NRC will still be controlling the use of radioactive materials and also the licensing and also the fees associated with it. It's
So the-
simply transferred over the applications necessary to manage the radioactive materials instead of under NRC. Currently, it's under New Hampshire because of this 1966 agreement state agreement between NRC and New Hampshire.
Thank you. That seems to be a situation like with environmental services where they have, where they are the agents of the federal government and that's essentially for Clean Air Act, Clean Water Act, et cetera.
And that is in RSA 125F14. That does state that that this is an agreement state.
With DES, for example, they could just let the EPA enforce the federal requirements, but the state chose to have DES do that because they thought it would be easier for the citizens of the state to work with a state agency and instead of trying to work with the EPA.
Okay, does somebody have a motion to resolve this? Or staff recommendation?
The committee could could of course postpone this if they wanted to have further discussion regarding it.
Move to postpone.
A motion and a second
What was your motion?
to postpone.
Postpone?
This may require a waiver. I'll ask him.
The deadline is December 19th.
The Nova waiver would be necessary.
Okay. Any further discussion? All those in favor of postponing?
Aye.
Any objections? Okay, thank you.
Can I ask a quick question?
Ask the staff.
Oh, okay.
Mike, you have the last item.
Is 100 taken care of too? Yeah. The last item is an emergency rule from Office of Alcohol and Drug Abuse Prevention. As you're probably aware, in certain instances, persons that have been convicted of drunk driving have been required by the courts to undergo counseling. They have to pay for that at their own expense, although there is provisions for indigent persons. The state, through HHS, through this Office of Alcohol and Drug, the former Office of Alcohol and Drug Abuse Prevention, licenses providers who actually provide the counseling to the clients. There is various fees that are required by statute and in the rules. The department had recently sent out a memo to the providers indicating that the providers could not charge for transaction fees. In other words, if a client paid for his fees with a credit card, then the agency was passing on the transaction fees from the bank to the client. The department said that that wasn't currently authorized. The providers said, well, it's been current practice and there was a cost that would be, it would strain their budgets. So the department agreed and put in the emergency rule that authorized the clients to be charged the transaction fee. There was also a provision in there that requires the providers to notify the clients ahead of time of this fee and let them know what it is before any charge is made. There seems to be authority regarding this. The rulemaking provision for authority is fairly broad, so it seems to be within their authority.
Okay, we don't take any action on this. Is there any other business?
Yes, staff would like to do a small presentation before the committee leaves.
Okay.
Essentially, we'd like to have some cupcakes and to thank the chair for his 12 years of service, 3 terms as vice chair and 3 terms as chair. Staff was very appreciative of your service, and we want to thank you.
It was only two as vice chair.
Okay. We have some cupcakes.
And
Okay, so-
interestingly, the only time that Jelcar wasn't able to meet in December was the December before Senator Reagan was appointed to Jelcar. He started in January of 2013.
Thank you for that. I'm honored that former director Scott Eaton is here today. And it's been a pleasure to work with the staff. And if everybody else, the rules people were here, you could write this down and send it to them. I always encourage them to agree with the staff because that's how it's going to come out. So we'll dispense with the continued meeting, and this meeting is adjourned.
Mr. Chairman, Scott came in because he wanted to say goodbye to you too. Thank you.